All right. Okay. Good afternoon, ladies and gentlemen. I'd like to call the meeting to order. We will begin by acknowledging that we're in Treaty 1 territory, the traditional homeland of the Métis Nation. My name is Ron Merritt. I'll be your chairperson this afternoon. Introducing the panel members, Karen Linkletter to my left, Mr. Bob Faluk, and representing the city of Winnipeg from the Assessment Department, Jeremy Pohl, and our recording secretary is Dawn Rojo. We'll be hearing an application for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested has been described in each application and will limit discussions to those matters. The statements that the applicant or the assessor make at this hearing are sworn in testimony, and anybody speaking in these matters must be sworn in. Please be advised that comparisons of assessment properties are not considered evidence of market value by the board. The board is appointed annually by City Council and is independent of it, along with the city administration. We make our decisions based on the evidence provided at the hearing and issue a written order that will be mailed to all parties. Please note that the board's decision in respect to application may be appealed to the manager of the municipal board if the matter pertains to assessed value or classification, or the Court of Queen's Bench if the matter pertains to application for exemption from taxation. Did you wish to appeal? Information how to do so will be included in the board's order. In respect to the hearing, I will confirm the matters to be addressed by the application following the swearing in. We'll then have the assessor's testimony followed by questions and the other applicant may have, and then it'll be the applicant's testimony followed by questions. Each party will have the opportunity to summarize if they wish. Once the evidence about the application is brought forward, the applicant may leave. This process will repeat for each item on the docket this afternoon. The session will close after the application is heard, and the board will deliberate in private and make its decisions. You will receive the order by registered mail as soon as possible. As information, all public hearings are live stream recorded and will be part of the public record. I'll ask our secretary to swear in Mr. Pohl and to affirm Mr. Newfield.
State your full name.
Jeremy Rifle.
And you swear to willing to back the science, the truth, the whole truth, and nothing but the truth, so help you God. Please state your full name.
Rocky Youthful.
And you have sworn to willing to back the science, the truth, the whole truth, and nothing but the truth.
I do. Well, gentlemen, we will go to Portage Avenue, 1867. And Mr. Pohl, there was a non-co-op issue, so maybe you can tell us about that.
I'll just hand up some information.
Okay.
Sorry, well, I thought we had exchanged evidence.
This is for the legal issue for the non-co-op.
I'm sorry, I thought we'd handed out evidence.
That's the quantum for the exchange, so we handle any legal.
So I'm just wondering here, like, we get to respond to a request for the penalty for non-cooperation, because it's the first time we found out about it, but I thought we had been presented all the evidence we needed to look at for it.
Is this new evidence?
This
Mr.
was
Pohl?
based on the claim that the appellant indicated that the city had possession of the property.
Okay, and it is applicable to the non-co-op
Only for
issue?
legal matter, you can bring in any, you can have a moment to look at it if he needs, you
Okay.
can adjourn to
Yeah,
look at it if he
well,
needs.
okay.
But there's no submittal deadline for legal argument.
That's not true. There's always an evidence deadline for primary evidence. And
For quantity.
if the city wasn't prepared the first go around, I
The city
don't know why
was
you get a
prepared.
second chance.
Well, I'm here to, resolve the matters, so I think, I don't think it's new evidence. It might be,
It's directly with the investigation, the claim that the appellant made that they didn't have possession of the property, and that it was actually bought in City Tax Hill and they had to find
okay,
it back
well,
from.
let's, I'm going to proceed with this. If Mr. Newfield would like to look it over and see what he thinks, if he
Sure.
thinks it's new evidence, or,
Oh, no, this is nothing, that's fine.
Yeah, sorry.
Something earth shattering.
Okay, okay. So, Mr. Paul, explain the non-co-op issue, please.
In relation to the non-cooperation issue, the claim to the felon made that the owner was in control of the property, but didn't have possession of the property, legal possession of the property, and that there was a tax sale, and that the property owner had to acquire the property back from the city. I investigated that claim. At that point I asked for the hearing to be adjourned so I can investigate the claims. At that point I asked for the hearing to be adjourned so I can investigate the claim. If we indeed were in possession of the property, if we had the property, then there might be some relevancy to that. After investigation, we were never in possession of the property. What happened was the property owner went into arrears for not paying taxes. We sent the first notice, which is the first page. If you look at the second page, it's the second notice. And then there was the third and final notice for the taxes that were yet to be paid. At that point, the city engaged someone, a process of server to serve all who had an interest in the property. At that point, I guess it triggered the property owner being aware that they were in arrears for
But
taxes.
basically, Mr. Paul, you've followed the procedure, what is normally.
Yeah, but I just want to make it clear
Okay,
that there was going to be a registered charge on the property, and there was an interest or a lien against it, if you want to look at it in those terms, but we never took possession of the property. That's only the first initial stage.
yeah, but.
And at that point, if it would get further down the road where
Yeah.
that was never paid, then we could acquire the property. We did not
Okay,
do
but
that.
basically you're following the procedure that, the non-co-op, they haven't completed the questionnaire or,
Well, the appellant's claim was that they didn't
okay,
get
well, we haven't
the-
heard, and I can't,
Well, we
you know.
did hear it.
Okay.
That's why it triggered my investigation. We heard that the appellant claimed that they didn't get the inquiry INEs because they didn't have possession of the property.
Okay, but, you know,
That's not, that's what the officer was.
okay, but I can't, I can see my writing on here, but I don't know what happened at that particular time.
Okay, so for a fact, the property owner had full control of the property for the entire span. All this was,
Yeah, but you're just following procedure, and you were asking for the non-co-op issue. So
Right.
that's what we're gonna deal with.
correct, but, Mr. Chairman, we could have dealt with it on that date. The appellant made a claim that they weren't in possession of the property, legal possession of the property, and that they couldn't be held for
Okay.
non-compliance because.
Okay, this is what you're saying, but basically, I just wanna say that your claim is that, there's a non-co-op issue, and these are the reasons.
Yeah.
Okay, and we haven't heard from Mr. Newfield, as far as I can remember, okay? So, okay,
Right.
so, so for the record, the city's seeking the non-co-op issue, correct?
Correct.
Okay. Mr. Newfield, your response?
Sorry, I don't know, are we finished with the presentation?
Well, as far as I'm concerned, yeah, it is your opportunity to say why your
No,
client
I just
did
had-
not.
I believe I just had one, maybe two questions.
Okay, okay,
But if the assessor's finished, then I can ask them.
okay, then I think he's finished for the time being.
Well, we didn't actually get to the failure part. That's why we're investigating the claim made by the appellant, like.
Okay, you can proceed,
So
Mr.
if
Paul.
you look at page 9 of the brief, they have not been reporting, returning the INEs for a number of years. On page 10, it's being sent registered mail to 1241 Wellington Crescent. Tracking numbers on the following page. And the INE that was sent follows on page 14. This was not returned. If you look on page 18, highlighted in blue, this is the former address that was being sent to, 1241 Wellington. And then it was changed to 1816 Portage Avenue, but it was changed on April 16th, 2019. And the whole reason why this was changed was the triggering of the arrears and taxes when the property owner became aware that it was no longer going to his former residence. There was a I guess, some issues with council, and it led back to our department, but the tax side of things, that wouldn't be part of my day-to-day review for assessment purposes. Partially, when I heard that the fellow claiming that there was a tax sale on this, and the property owner had to buy it back, I didn't see a sale. The reason why I didn't see a sale is because there never was one. They simply paid their arrears and taxes and the penalties because they felt were at fault, and changed their address accordingly. So, by definition, we were sending it to the same place, again, at 1241 Wellington. That's the last indication that we had to send it to. The property taxes were in arrears, so they're going to the same place. They still had to pay the penalties, they still had to pay their taxes. There was no leniency on that. That was handled in a separate matter. But we still send the IDs to the same address. So at this point, we now have, as of April 16th, 2019, the address that they prefer, or they want their ID sent to, which would be
And what address is that?
the subject property's address at 1868 Portage. So they are in failure of reporting. Circumstances involved, my understanding that there was a divorce. I don't know the reasons behind that. But their failure here, they did return their IDs, and we're asking for the non-compliance court. And we're also
Mr. Newell, do you have any questions?
Yes. The request for reversal of burden of proof, is that based on the mailing that you haven't attached?
the failure to report.
Is this the mail, the year in question? The one that was sent out?
2017 is the year that the failure. The other years are just showing that they haven't
No,
reported.
the question was this letter of April 12th, 2018,
Which page do you want?
page 12, and the follow-up request on, I take it, June 7th?
There's two mailers, yes.
Okay, so that's what the subject of your request is this particular mailer?
Both mailers. We send up initial one, which is the failure.
Right,
And
April
then we
and-
send up a follow-up certified mailer with the exact same mailer.
Right, April and June of 18.
Yeah.
Okay. And just clarify, you said that page 11, this is the registered letter, was never delivered, it was returned, is that correct?
Yes, it was returned.
And that was sent to 1241 Wellington,
Correct.
okay? And.
On June 8th, 2018.
Right, okay. And this information you provided today, this is a tax bill statement. The last date is August 14th, 2017, and a letter November 6th, 2017. Now, these particular letters, do you know if the owner received them at all either? Just
They actually served the owner. That's when the owner became aware that they weren't paying their taxes.
I know when they served the owner?
I didn't have the actual serving date. That wasn't part of the scope.
Was it not in 2019?
Most likely, it's not.
Okay.
They paid their arrears on June 7th, or everything was satisfied on June 7th of 2019.
2019, okay. Now, last question, who is Michael Jack?
I believe he was the former CAO.
CAO? So, he would be in what position in regard to assessment and taxation?
We have a director, our director answers to city council.
Would he answer to Mr. Jack?
Well, obviously, yes.
Okay, thank you, those are my questions.
Panel members, any questions of the assessor?
No, I have none.
Okay, Terry?
Mr. Cole, just on page 2 of your brief,
Yeah.
so they stopped sending the request for information in 2016?
No, they met, no, if you look on my page, same with the
On
taxes.
Wellington Crescent.
Yeah, same with the taxes.
Okay.
IDs weren't returned, taxes weren't paid until the process happened where, as you see on the pages here, where there was leaning towards going to a tax sale. And then property owner was served, became aware that it wasn't going to the right place,
And then in,
triggered, but it triggered an address change.
right, so in June of this year, you paid.
Yeah,
Okay.
the address change was on April 16th.
Do you happen to know how long this business has been operating at this address?
At least since 2009, and from past 2009.
So you don't know for how long he had been cooperating and sending in that bill?
Oh, it went back 10 years, so at that point, I don't search any further.
Okay, thank you, that's all my questions.
Mr. Newfield, your explanation?
Sure, got some response.
So there are 5 things.
There's three.
Three separate.
They're all separate.
Oh,
I separated them all for you.
sorry.
So did I just get 5 of the same thing? That's what I thought. I need one.
You need a whole package.
He's saying,
Thank you, madam.
I lost one, but it's okay.
I have,
You have
we
two
got
of
one more, yeah.
I had them all in order too now.
No, I'm sorry, I just stole
Our
the-
secretary is too efficient.
No, I have
So-
2 of these now.
So just to make sure
So someone's missing one of these.
I have three
okay, what are we
here.
supposed to have?
yeah.
You're supposed to have one
A
of
letter
this
from,
one.
letter from the property registry, a tax statement,
One of this one.
and
Yeah.
a long email
And
string.
this one.
Okay, so I have those three.
Okay.
Do you have,
Someone's missing this one.
I don't have that.
Okay,
Thank
and then you have my other one.
Okay, could be.
Yes,
Okay.
okay.
So
Good.
next
Sorry, I'm
next time, let's have a meeting and let's sort of figure out how we're gonna.
I don't wanna waste paper clips.
Sorry.
Mr. Newfield.
Okay, first document is from the property registry. This was received by the owner April 10th, 2019. And in it, of course, the registry tells him that as of December 8th, 2017, his land has been put in tax sale. So you'll note that the dates are very important here. So these documents the assessor gave us, there's nothing to them in relation to this because they happened after this statement. So the registry put this on tax sale. Now, the second page of this gives you a bit of a description on what they're doing. It's being put aside for tax sale, and unless you either challenge the tax sale or redeem the property from tax sale, you will be forever stopped and debarred from setting up any claim to or in respect of the property. Well, a layman's view of tax sale is that when you're in tax sale, you've lost your rights to your property. You can't sell it, you can't mortgage it. You can use it and reside in it until such time as you get kicked out if you don't redeem the property. But it's frozen, and this is the property registry's service on the owner. The delay in receiving it was, they were sending it also to this address on Wellington. The there's an explanation on the Wellington, the owner hadn't lived there for several years. November 5th, 2014, there was a petition for separation, and the matter isn't resolved yet according to the Justice Registry. There's 119 entries in the Justice Registry. It's looks like a pretty lengthy, messy divorce, and it's this man's private business, and so we don't want to go there other than just the dates. And he was, I believe the house was sold in between as well. And the next document is the tax statement, the realty tax statement. And you see that it opens up December 31st, 2014 with a zero balance. The petition for separation or divorce was November 5th. So as of that date, the taxes were paid. And then at that point, there were no more payments on the taxes. All statements went to the house. So the second page is the last entry, transfer to tax sale. And that is dated December 8th, 2017. So at that point in time, the account was shut down. And the tax sale account got it all. The next is a document, some communication that began in May of a bit earlier, April, read this backwards, sorry. April of 2019, between the owner and Michael Jack, who I guess his position was Chief Corporate Services Officer. And this was after the process server actually served the notice. So all these documents, anything that happened, were never received. And there's the story is in here. There's some interesting comments here. And that on the second page, third paragraph, Mr. Jack spoke to the city assessor. He confirmed that no correspondence was sent to 1241 Wellington regarding 1868 Portage Avenue was ever returned to the department as undeliverable until April 11th, 2019. So in this process, which went from 2014 to 2019, the Chief Corporate Services Officer of the city, in consultation with the assessment department, said that nothing was ever returned as undeliverable. And yet, the assessor today has a document that said something was returned undeliverable. And the rest of it is there for you to see the history of what happened here and the complaint, the owner admitting service April 9th, 2019, and the circumstances of non-payment of taxes did not happen with intent. There seems to be a significant breakdown in communication, as the owner's statement. And not only with the tax sale situation, but the confusion in the assessment department about whether or not there was some undeliverable mail return. So I'm presenting what the owner has provided me, and his claim is that legal possession was terminated December 8th, 2017. It was redeemed in April of 2019. Therefore, under his belief is that under the charter, and I'm saying his belief not because I don't believe it myself, but I'm not a lawyer, I'm not here to argue law. So I've been only just repeating what his position is. So you don't think I want to argue law, was that without lawful possession of the property, service has to go to the lawful owner. This was in a state of limbo. Service should have been made likely to, I don't know who, maybe the registrar, or actually there's a department in the city that looks after tax sale. Perhaps they should have received it, and you can see in Mr. Jack's response. Oh, I didn't put in that letter. There was another letter where they went through the procedures, and I'll just verbally give you what they said. Is, after he contacted his counselor,
Who is this again?
the owner, Mr.
Okay,
House.
okay.
Yeah. I have another letter here, if you want this for the record or not.
You can verbally state
Okay.
it.
And it discusses that notices on tax sale are also only go through mail, that they don't use anything into a processor until they're at the final stages.
I think that should be put in as middle.
Okay, okay.
And it talks about.
You want a copy?
Yes.
Okay, so we'll make you copies.
Yeah,
Okay.
it talks about the process. It says that there's 2,000 letters sent a year, 1,800 for second letter, final notices, 500, sold at tax sale, 300, redeemed from tax sale, 150. So it has all these processes, and then they talk about the sheriff finally tracking, being assigned to the sheriff to provide service in 2019. So this letter came from, you know what, I should give you this one instead, because this one is part of an email, it's the same content, and it was addressed to, from the counselor to Michael Jack, Kelly Shields, and the owner.
Okay, we'll get, when we have a little break,
Right.
we'll make copies
Yeah.
of it.
Okay.
Yeah.
I didn't touch them this time, so.
Now, do you just want that one, or do you want the other?
No,
one too?
no, this
Okay.
is, this is just a.
Okay.
That's got some more information, and the email string is rather interesting in that it has all the parties who were contacted for this. I have a timetable that was prepared by the owner as well, and it doesn't add anything to our debate today, it just confirms what,
So,
oh, here's a good point. He's owned it since 1993, 21 years, paid taxes with no penalty or default. And big hole between December 8, 2017 and April 9, 2019.
and there's a reason.
Yeah, well,
Okay. So, these are the reasons why he is in non-compliance?
well, I suppose the reason is that
He wasn't in possession of the property? Is that what you're basically saying?
Well, one reason is that he never received the request, it wasn't sent to the owner, the proper owner, and it was returned. And the second would be, yeah, he's, at this point, with tax sale, I'm not sure he's obligated to, or it may be illegal for him, as that second page on the property registry said, from responding on this property. Although he didn't know it at the time.
Okay, Mr. Poole, questions?
Yeah. The party, the owner was responsible for paying the penalties to get his property back, along with the taxes that he owed, correct?
He did pay them. He claims that the visual responsibility is another one altogether, and not something I'm involved with, that he did pay them.
He did pay, and when he paid them, he redeemed his property, correct?
That's correct.
So his property never was sold, he never bought his property back, he simply paid his taxes.
Well,
So there was no sale.
So,
it was redeemed from a situation where
But
he
you can-
lost care and control.
yeah, but
No.
you can remedy the default, can you not?
That's correct.
I'd like to make it clear, if there was a charge registered against the property with property line title, or property registry, property owner was served. property owner was
Yeah.
made aware of it at that point.
There's a notice that goes in the paper
At no
for
point
tax sale.
did the city ever bar him access to his property, prevent anything. He had full control and ownership over his property. That's never changed. There was simply a charge put on the property, which indicates it's going to go down the line to basically getting to that point.
I don't
So
know if-
my question to you
If that was
is,
Yeah,
answers in
just
that.
questions and answers, please.
my question to you is, are you claiming that the property was actually purchased back from the city?
Well, I believe redeem is a synonym for purchase. You go in and you redeem something, it's a legal word. I know, and I'm only speaking as an appraiser, that anytime you have a title that has these charges on it, you lose rights. And you own rights, you don't own the property, so he lost rights, his rights to sell it were lost. Yeah, so that's how ownership is determined. So the question is, who's the owner? And, usually it's the person who has the right to sell a piece of property. And the only person who's exercising those rights at the time is the city of Winnipeg.
That's nonsensical, is what I would say.
Okay, let's,
Secondly, when he paid taxes, the reason was because everything was being sent to the Wellington address, correct? That was the position?
Well, the notices were being sent to Wellington.
And yet he was still found at fault and needed to pay the penalties and taxes.
No, he wasn't found at fault. There was a claim made on it, and the property was, rights were seized for tax sale. He missed the opportunity to argue his case.
Did the property owner ever tell the city of Winnipeg to change the address to,
When he became aware that the address was
but
incorrect.
he never asked prior to that?
The documentation speaks to it when he made his request.
So I'm not asking that, I'm asking, was there ever an address change, an address of service change by the property owner prior to being served, and the rationale? comes
I
after
only
that?
know what was provided here, and that's what I'm here to
Mr. Poole,
present.
did the department seek legal advice in regards to this? No.
I simply spoke to management and got the information, which indicates that they paid the arrears, they redeemed the property, they always had ownership over the property. You can't purchase a property and get ownership that you already have. So they were responsible for the taxes.
Yeah.
And that address of service change came after all of that. And there was no other address change leading up to that. That's clearly indicated in the communication from the property owner through city council to us and the department of management.
Okay.
So at this point, it's proving that they never made a request after the divorce or whatever happened in the divorce for a separate change of address. There were arrears for taxes and for IDs. They didn't inform us of where else to send it, so we kept sending it to the same place.
Ms. Linkletter, any questions in regards to either party?
Yes. So Mr. Neufeld, all the communication was sent to this address on Wellington, what is it, 1241 Wellington?
Well, that's where they were addressed, and I have no reason to believe they weren't sent there.
Okay, so when did the owners cease living there?
Just one second here. I had mentioned the petition was November 5th. I imagine in around that date,
Right,
What
that
year?
was,
2014.
right, so that was the petition for divorce.
Right.
Okay, so do you know if the owner had left prior to that date?
No idea.
Okay,
He informed me that he had found out that documents were going to his former address, and informed me that there was a separation, and that's as far as I really wanted to hear about it. The rest I found in the Justice Registry. Just a respect for people's privacy. Motions filed November 18th. Doesn't say anything about habitation in here.
Okay, so that's November,
November 5th, 2014.
okay. So do you have any knowledge as to whether the other party in this divorce was continuing to live in the house? And/or was the house sold between November of 14 and, when did this letter go out? April of 2019?
No, I never asked. We don't know.
Okay. And the owner has been in business since, I think you said 1993?
In this property, yes.
Correct, has always paid his taxes.
Yes.
So he wasn't aware that he hadn't paid his taxes?
My understanding was that the billing information came to the house in Wellington, and they had made financial arrangements that way. Don't know if it was tip or what it was, but I think it was I can't say without knowing, and I didn't ask the question, but my assumption is that this property became part of the assets at dispute.
Okay, but I guess my question is, since 1993, so 21 odd years he'd been paying his taxes. And then,
Yeah, on March 16th, 2017, there was demand for financial disclosure.
sorry, what was that date?
March 16th, 2017. So that and the financial disclosure would be the property through the time of marriage. So that's my understanding, and I think with issues like this, my instinct is always, I don't wanna really know anything about the person's personal affairs. I think the facts are simple: no possession of the house and no service.
Okay, thank you, that's all my questions.
Thank you, Mr. Fluke. Any questions?
Yeah, I do. I drove by the building today. There seemed to be a sign in the window. Couldn't tell what it was, pink window. Is it in operation right now?
Yes,
And what's in there now?
the chiropractic clinic. Last I spoke to you.
And it's not run by, is Dr. Cost still there?
Yes, last time I spoke to him, yes. He was talking about working there, yes.
So it's still known as Cost Chiropractic Clinic.
That's correct.
And of course, being a business, you would get financial statements and so forth every year.
I think that's a safe assumption, yes.
And so wouldn't it come to his attention that no property taxes are being paid year after year after year?
Well, I guess we'd have to ask him that, that's why I gave you his statement, which was that there was some form of communication breakdown. Because what you're asking me is a question that I, as an appraiser, I'm just not, this isn't my field, right? I am not here to answer to.
But whether you're an appraiser or not, you're representing this gentleman in this regard.
I have
As a result, some of those questions
Right.
would be handy if you would ask them.
I have
So
a
in effect, we would
right.
get more information.
That's a fair request on your part. I didn't go to the trouble of asking those questions because my original hope was that this hearing, we had actually asked for our part of this was to ask for an adjournment to bring in legal counsel, and then it was scheduled for this date, and legal counsel wasn't available. So I briefed myself on what I can, what I know, and what are the facts.
Legal counsel on behalf of Dr. Cost.
That's correct. And that they weren't available today. So I'm providing you with the information I was briefed on, and the information I know. And I'm certainly not trying to withhold anything. It's painful enough when you look at what's listed in the Justice Registry about what the issues these two people were facing, that to have them aired again in a public hearing is, for me, something I don't wanna do.
So Dr. Koss ended up paying all the arrears and taxes,
That's correct.
and is the property still now in his name?
Yes, as a matter of fact, there's a follow-up letter from the registry saying, this might be of interest as well. His rights were returned to him to appeal his taxes from Property Registry Manitoba. I'm sorry, I was just looking at it earlier. The property registry sent him a letter when he paid his taxes off in, I think it was June or May, informing him that he now had the right to appeal his taxes, which to me would infer that he had lost that.
And what year would he be able to appear?
2020, it actually said on the letter, I'm just looking for it.
Okay.
Yeah, it's in the letter from, which I gave to Bella, it's included in
Okay.
there, from the answer provided by the city. Does Mr. Koss have any opportunity to appeal previous notices? Mr. Koss would be able to appeal his 2020 assessed value.
I have another question. This listing that you gave me here, gave us, in regards to transfer, land sale at the bottom,
Yes.
and when you showed 8,000 being transferred, I don't think that we got everything on this page. Something got cut off at the bottom here, because it's not in line with total payable. And I'm assuming that the amount should be 66,000 instead of 33, and then you said, so you almost gave the impression that that's when it stopped. And-
Well,
and I don't think that's correct.
No, but you see the little dotted line there, that corresponds to the dotted line on the previous page? So this
Yeah.
is the extent of his
Yeah,
statement.
but I don't know, that's what I was trying to understand.
Yeah,
Because in effect, when you go back to the first page, you end up showing on December 15th, 6773
right,
transfer, but it still stays at 6773. And then in this particular case, the same thing up above, the next page, 83, gets transferred, and the balance stays the same. But
Yeah.
anyways, there's more to that page than what was copied.
this is what I have, and this is what I was provided. So, I look at this as a termination of the tax account, because it's been transferred to tax sale. And that's, you have the other
So
letter.
this would be the actual total, 66,000.
Oh, I see what you're saying, yeah, but this was also dated May 27th, right? There could be more, I think I don't know, this is what the owner provided me, so.
Okay.
As of the date of the statement, it just, for us, looking at this, it was transferred to tax sale.
Thank you.
Thank you. Harry, you have another question?
Yeah, Mr. Neufeld, I'm just wondering, during this whole process, as far back as 2014 to, I'm gonna say to present day, has Mr. Goss been operating his business out of that building?
I believe so.
Okay, so at no time was he barred from the building, or there was locks on the door, or anything of that nature?
I don't think so, no.
Okay, thank you, that's all my questions.
Right, I think,
Can I have a summary if that's all right?
sure.
For the non-compliance element, we had Madras of Wellington, we sent the IEs to, that's where we sent them. We sent them there for years, we sent a certified mail. We never had any response. There's been no, up until the April 19th, address of service change which had provided to you, as the property owner made us aware that it shouldn't have been going. That was his former address. At the same time, so right there, they haven't responded and they are in failure to respond to the IEs. That should be the end of it for the non-compliance side of it. At the same time, they didn't pay the This was investigated at the city council level and all the way down to our management, all the way down to our tax manager. I reviewed it with her, Ms. Jones Appel. This property had the exact same issue for paying taxes. It went into the tax process and was eventually, they were not gonna pay their taxes and the penalties associated with it. It was going to go for sale. There was a charge registered against the property. That property, once it was served, was made aware, the property owner was made aware, and then paid the taxes and the penalties accordingly. They paid their taxes and the penalties as you see from the total here. They were never not the owner, they were always the owner. It never went to be acquired by the property. They didn't purchase the property for $64,000. That was just the amount of arrears and penalties that you see outlined here. They were always in ownership of the property. We never barred them access to the property. It shouldn't be an issue. The tax side of things proves our point that we're sending it to the right spot. They never made us aware. Now, whatever happens in a private divorce, none of our business. They didn't inform us. Plain and simple. They were responsible for paying the taxes and the penalties. They should be responsible for the non-compliance penalty. Thank you.
Thank you. Mr. Neufeld?
And again, I repeat myself, I'm certainly not making legal argument, but I'm just repeating the facts as I know them. No service was ever achieved. Often I listen to these penalty cases and an interesting question always comes up, well, did you pay the taxes and miss this bill? And the board would say, well, if you paid the taxes and then you didn't respond to this, you know, you must have known. So in this case, no, he didn't pay the taxes either. Now, the man has paid his penalties. It's $50,000 additional it cost him to redeem this property. So whatever else the city would like to penalize him for is, to me, sounds like really insult added to injury. And you know, he's taken the blame for it and had to pay that out. So I think the deed is done, myself. And the issue really here goes to the service issue. And the rest of it just gives you the reason why there could be no service. But just correct this, let's be very clear on the specific point of ownership of a property. Ownership is not, I got the key to the door. Ownership is based on a right that is granted to you. All land in Canada is theoretically owned by the Queen. She gives her subjects the right to ownership, to a form of ownership, which is called fee simple, which you get a title for. Your ownership is based on those rights, the rights to use, the right not to use, the right to sell, the right to not do any of the above. And that is what is appraised, the rights. When you're in tax sale, you lose some of those rights. You maintain the right to use for a limited period, but you use the right to sell. Now, someone in tax sale cannot sell their property. It's tied up at the registry because the city said, we're number one in line here. We're not giving you any rights. We're first. So just bear in mind that it's about property rights, not who's sitting in it when. And it was a very unusual case, and I wish you luck with it.
I thank you. We're gonna shut down the camera. You gentlemen will take a recess outside the door there. And in the meantime, we'll make copies of this. And we'll call you back when we're conclude. Okay, we'll call the hearing back to order. And after discussions, we are granting the non-co-op to the city. So Mr. Newfield, your presentation.
Oh, okay, and my instructions were asked to the assessment be confirmed.
Okay.
That was your decision.
Okay, so I think what we'll probably do is Mr. Cole just read it into the record, the roll number, the address, and the value.
File number is 191365. The realtor roll number is 070201580000. Civic address is 1868 Portage Avenue. The 2020 assessment is for $384,000. Given that that's going to be confirmed, you need me to go further.
I thank you. I think that about clears everything on the docket. So, Mr. Newfield, thank you for your attendance. Mr. Poole, thank you.
Can I just get a copy of that?
Yes.
No, I left it with your
Yeah.
document.
Oh, was that this one?
Yeah.
Oh,
It says Scott Gillingham.
yeah, got it.
So thank you.
Thank you.